Whether you wear a badge or not, if you care about courage, clarity, discipline, and the price of decisions in the moment that define lives, you've come to the right place. This is where training meets consequence, where the law collides with human behavior, and the fog of uncertainty tests the limits of reason. These are the stories of pressure, of purpose, and what it means to hold the line when the world loses balance. I'm Don, a police officer, instructor, and founder of Forecast Securities Group, and I'll be your guide through the storm. Welcome to the Conditions Report. Hello, everybody, and welcome back. We're taking a break from some of the drone content because, well, we're getting unseasonably late rain, and it has been pouring down for the last couple of days. This is episode 26, and it is about totality. I'm Don, and this is the Conditions Report. If you've already been listening to the show, well, then you know the premise. And if you're new here, well, here's what you need to know. This is the weather forecast for street cops, detectives, and admin, what's coming, what's changing in the environment that we work in. Before we go any further, a quick disclaimer. I am not an attorney, and nothing discussed on this show is legal advice. The views expressed here are those of Forecast Securities Group and myself, and they are a exercise of protected American free speech. If you need legal advice or guidance specific to your agency or jurisdiction, you should consult qualified legal counsel. This podcast is for educational and informational purposes only. We're not here to judge officers involved in the incidences or to second guess the decisions with the benefit of hindsight. The point is to learn from their hard-earned lessons on our behalf and improve as a team. In this episode, we're going to examine a recent United States Supreme Court case decision called District of Columbia v. RW. It was handed out yesterday, April 20th, 2026, in a concise per curiam opinion. The court reversed the District of Columbia's Court of Appeals and delivered a clear, practical victory for law enforcement on the Fourth Amendment standard for reasonable suspicion. The case arose from a late-night Terry stop in Washington, D.C., an apartment parking lot where officers responded to a dispatch call report of a suspicious vehicle. Two passengers fled unprovoked the moment a marked police car pulled into the parking lot, leaving the doors wide open, and the driver immediately began backing out of the parking spot in the suspect vehicle with the doors still ajar. The officer blocked the vehicle and conducted a brief investigatory stop. And the D.C. court suppressed this evidence by excising the dispatch call and the flight of the companions from the analysis, focusing only on the time of night and the slight movement of the car. The Supreme Court rejected that divide and conquer approach outright and reaffirmed that reasonable suspicion must be judged on the totality of circumstances, the whole picture, not isolated fragments. For street officers, detectives, and administrators, it clarifies on how courts will review the stops we make every shift. It reinforces that dispatch information, unprovoked flight, and collective behavior of occupants all count when we articulate the facts that gave us reasonable suspicion. The constitutional stakes are straightforward and directly tied to our daily work. The Fourth Amendment protects liberty without handcuffing officers who must make swift, common sense judgments based on everything they see and hear in the moment. It all started like so many graveyard shift calls do. Around 2 a.m, an officer from the Metropolitan Police Department of Washington, D.C., received a radio dispatch directing him to check out a suspicious vehicle in a specific address in an apartment complex parking lot. This is not a flashy call. And just like all these kinds of calls, it lands on patrol shift every single night. The officer drove there in his marked patrol car, and as he turned into the lot, he saw a car with people inside. The moment his headlights swept across the vehicle, 2 individuals immediately fled from the back seat unprovoked, running into the darkness after nothing more than the sight of a police car pulling up. They left at least one door hanging open. The driver, a juvenile identified in the court records as RW, did not freeze or step out. Instead, he put the car in reverse and began backing out of the parking space with the rear door still wide open. The officer did what any experienced police officer would do. He positioned his cruiser to block the car, stepped out, and ordered the driver to show his hands. He drew his service weapon for his own safety while he sorted out what exactly was happening. The stop lasted only a couple of minutes. It produced evidence that led to delinquency adjudication against RW. At the suppression hearing, the defense argued that the officer lacked reasonable suspicion for the initial seizure. in the trial court disagreed and denied the motion. On appeal, the District of Columbia Court of Appeals took a different path, relying on its own recent precedent. The appellate panel decided it had to evaluate each piece of information in isolation before weighing anything together. It excised the radio dispatch entirely, ruling that it was too vague and unsupported by testimony about its source. It also excised the flight of the two passengers, concluding that their sudden departure did not point to specific criminal activity by the driver. And with those facts removed, the court was left only with the late hour and the slight backwards movement of the car. That it held was not enough, and the convictions were vacated and the evidence was suppressed. I know what you're thinking. That sounds ridiculous, and it is, because anybody who's been through a situation like that would know that these puzzle pieces most certainly fit together. The District of Columbia asked the Supreme Court to step in, and yesterday the court granted certiorari review, reversed the D.C. Appeals Court opinion in a per curiam opinion, and remanded the case for further proceedings. The justices made clear that they were not rewriting the law, but that they were simply insisting that the law already on the books must be followed. Reasonable suspicion, the court reminded everybody, arises when the detaining officer has particularized an objective basis for suspecting criminal activity may be afoot. That determination must rest on the totality of circumstances. We've all heard that before. In the opinion quoted by the United States v. Arvizu and earlier precedents to drive the point home, the court may not engage in divide and conquer analysis by isolating individual factors and rejecting them one by one before ever considering the collective picture. The whole is often greater than the sum of its parts. In this case, the dispatch report, the unprovoked flight of the companions, the door left behind open and ajar, and the driver's immediate attempt to leave with the door still open in the late hour all belonged in the same frame. Taken together, they supplied an officer with ample reasonable suspicion. The D.C. Court's method of pretending the most revealing facts never happened was incompatible with the Fourth Amendment framework the court has applied for decades. The decision lands at a time when patrol officers across the country face increasing scrutiny. Every time they initiate a brief investigatory stop, body cameras will capture the moment, the defense attorneys will parse every second, and appellate courts sometimes review the records with the luxury of the beautiful hindsight and divided lens. Officers know the stakes. A single stop that survives suppression can remove guns from the street or interrupt a pattern of violent crime. A stop that gets thrown out because a court excised key facts can leave dangerous conduct unchecked and expose agencies to civil liability. The facts in District of Columbia v. RW are the exact kind of facts officers encounter nightly. A dispatch tip, sudden flight, unusual driving behavior, and the hour of darkness. Nothing else, the incomplete picture. And the Supreme Court's message is a practical and direct one. Document everything, articulate the whole picture in your report and in your testimony, and do not leave reviewing courts to slice the facts into pieces that, standing alone, look innocent. The totality is where it matters on the street and in the courtroom. The current conditions are this. The legal framework at issue is the Fourth Amendment's protection against unreasonable seizures and searches. The long-standing established standard for brief investigatory stops first recognized by the Supreme Court in Terry v. Ohio in 1968. In that case, Cleveland Police Detective Martin McFadden observed two men repeatedly walking past a storefront, conferring and peering into the windows in a manner that suggested they were casing the store for a robbery. McFadden stopped the men, patted them down for weapons, and discovered a pistol on one of them. The Supreme Court upheld the stop and frisk, holding that an officer may conduct brief investigatory detentions based on reasonable suspicion supported by specific and articulable facts. The criminal activity may be afoot. The court emphasized that the standard is less demanding than probable cause, but more than just a hunch. It must be grounded in a practical consideration of everyday life on which reasonable, prudent officers act. Over the decades, the court has refined this standard into the totality of circumstance test. In United States v. Arvizu, decided in 2002, the court addressed a border patrol stop in which an officer observed a minivan on a known smuggling route. The driver avoided eye contact, had children in the back waving stiffly, and the vehicle slowed to an unusually slow speed. The Ninth Circuit had analyzed each observation in isolation and concluded that none was suspicious. The Supreme Court reversed, holding that reviewing courts must consider the whole picture rather than engaging in divide and conquer analysis. Factors that might seem innocent standing alone can become probative when viewed together with other circumstances. The same principle appeared in Illinois v. Wardlow in 2000, where an unprovoked flight in a high crime area contributed to reasonable suspicion, and in the District of Columbia v. Westby in 2018, where the totality of facts surrounding an apparent unlawful entry supported probable cause, even though individual pieces might have been ambiguous. The DC Court of Appeals in RW departed from this line of precedent, and it treated radio dispatch as irrelevant because the record did not detail the caller's basis for suspicion. It treated the passenger's flight as irrelevant because the flight was not directly attributed to the driver. And by excising those facts, the court was left with only the hour of the night and the driver's slight backward movement in the vehicle, which it found insufficient. The Supreme Court rejected this approach in no uncertain terms. Reasonable suspicion does not lend itself to an on and off switch or a mechanical checklist. It requires officers and courts alike to assess whether the detaining officer had particularized an objective basis for suspecting criminal activity. And the opinion emphasized that the totality of the circumstances test precludes the evaluation and rejection of factors, isolation from each other. The whole picture, the court said, is often greater than the sum of its parts. Peer-reviewed research underscores this holistic approach. It's essential on the street. In a 2023 experimental vignette study published in Policing, an international journal, they presented realistic traffic stop scenarios drawing directly from U.S. Court of Appeals decisions to 396 working officers across 6 states. Officers rated the presence of reasonable suspicion and their likelihood of extending the stop to further investigate. The study parsed the data by manipulating key vignette facts, including how individuals reacted once the marked patrol car entered the scene. The presence of the patrol vehicle, its very self, functioned as an environmental stimulus that shifted the observable baseline behavior. Normal, law-abiding individuals typically continued routine action with minimal deviation. Greater deviation, sudden flight, evasive maneuvers, or abrupt attempts to leave produced statistically significant increase in officer reasonable suspicion judgment. Officers' assessments aligned closely with the court's rulings when they weighed the full context rather than isolated elements, demonstrating that the higher the behavioral deviation from a patrol car adjusted baseline, the stronger the inference of criminal activity afoot. These findings provide empirical support for the Supreme Court's insistence on totality. The patrol car is not a neutral background. It is an objective stimulus that alters the observable picture, and the court must weigh the resulting deviation as part of this whole mosaic. For working officers, this decision, reinforced by the empirical research data, is a practical roadmap. When you write reports after a stop, include everything, every observation, the dispatch details, the time, the location, the behavior of every occupant, any flight, any unusual driving maneuvers triggered by the sight of your vehicle. And when you testify, walk the court through the sequence as you experienced it yourself. Explain how the patrol car itself shifted everything in the environment, how the deviations you observed fit the totality. Appellate courts are now on notice that cherry-picking facts or excising inconvenient ones will not survive review. The ruling also reminds supervisors and trainers alike that field training must emphasize holistic assessment of the totality of circumstances. Officers cannot be expected to ignore reliable dispatch information or the plain meaning of unprovoked flight, simply because a reviewing court might later decide those facts are dispositive in isolation. The Supreme Court has drawn this bright line. Totality means totality. The Fourth Amendment permits brief investigatory stops when the facts known to the officer, viewed in their entirety, provide reasonable suspicion that criminal activity may be afoot. That standard both protects public safety and individual liberty by allowing officers to act on common sense judgments drawn from the whole picture rather than requiring them to wait for conduct that would satisfy a probable cause requirement. By insisting that appellate courts apply the same totality test the officers apply on the street in real time, the Supreme Court has given practical guidance to every police officer who must decide in split seconds whether to initiate a stop or not. And the decision strengthens the legal foundation for proactive policing while reminding all of us that the Constitution demands discipline, fact-based judgment grounded in the real world. That brings us to today's leadership navigational aid. Oliver Wendell Holmes Jr. wrote, The life of the law has not been logic, it has been experience. The leadership principle illuminated by this case is that constitutional leadership in law enforcement requires officers and supervisors to evaluate reasonable suspicion through the lived experience of the street, considering every relevant circumstance together rather than dissecting facts in isolation. Agency leaders must train officers to document and articulate the entire set of facts from beginning to end that gave them reasonable suspicion so that courts reviewing the stop are forced to see the same whole picture the officer saw in the moment. When patrol reports or testimony omit key details, we undermine the very balance the Fourth Amendment demands. The responsibility leaders carry when exercising authority is to ensure that every stop is supported by a complete, honest record and the circumstances are as they unfolded. The work of policing already places us in a very sensitive line between authority and liberty, upholding the Constitution with absolute fidelity to the totality standard, no matter how tempting it may be to simplify the analysis after the fact. Now, looking ahead, the Supreme Court's clear directive on totality of circumstances will obviously shape how agencies train, how reports are written, and how suppression motions are litigated for years to come. And body-worn camera and in-camera video will make it easier to capture the full sequence of events. Yet the responsibility to articulate the collective weight of those observations still always falls on the officer who made the stop. Evolving legal doctrine may test the boundaries of dispatch reliability or the weight given to flight in a particular neighborhood, yet the core requirement remains unchanged. Courts must view the whole picture. Institutional pressure to avoid stops that risk suppression will continue, but the public scrutiny of crime trends will push agencies to remain proactive. And I know what you're thinking. A lot of agencies are scared to be proactive or they're afraid to take on the liability. But the reality is, leaders and officers should rely on careful judgment, their own constitutional discipline, and thoughtful, effective training that emphasizes the practical experience. Train in totality, right? This includes pre event conduct, this includes how we work up these calls and how we respond. The environment will stay demanding. Yet, the measure of our profession remains whether we protect both safety and the constitutional principles that make the work worth doing. So, in simple terms, it's this. A lot of times we make stops and we see things that we don't immediately know are criminal. Yet, if there are facts that can be put together that make suspicion articulable, right, we can take action and avoid allowing crime to continue. Now, obviously, this is going to be department and jurisdiction dependent. There are agencies that will come after people for being proactive and getting the department into litigation. So engage at your own risk. But I think this is a positive step from the court. And I think it's also a realistic reevaluation for the public to look at how officers sometimes have to make these choices, right? And as long as the choice is a reasonable one, and not based in some sort of bias or extreme behavior, usually it's going to probably be okay and be legal. As we close, let's remember the point of this show is not to pass judgment or to revisit decisions with the benefit of hindsight. It's to learn as a team and improve. We're all leaders, so keep the L&A in the back of your mind. The work is complicated and the environment is demanding, and none of us get it perfect. Stay hungry, stay humble. I'm Don, and this has been the Conditions Report.